What's wrong? You can't do that. Permission to do what though? Did I not make you a co-host? You were a co-host. Oh, I wonder if I took it away from you. Here, let me do it now. There we go. Now you're co-host. Okay. I'm going to mute myself and I'll bring everybody in, Judge.
All right.
I'm gonna pull up on my computer.
Yeah.
Can everybody hear me?
All right. This is in cause number 20-20413 in the matter of the marriage of John A. Nixon and Tina Tyner Zapalak Nixon for hearing on the respondent's special exceptions to the first amended petition for divorce. I guess the first thing I need to clarify is, do I need to take any action on the motion for leave to amend before we take up the special exceptions? Ms. McClyman?
I'm sorry, Judge, a motion for leave. I don't think that that's necessary now because I think that with the reset, it doesn't matter. It made it moot.
Well, I just wanted to give you the opportunity to talk about that for a moment before we moved on straight into the special exceptions.
No, I understand.
Judge,
I don't know that
Miss
Ann
Wynn's
went.
not on yet.
Right. We're missing Ann.
Well, she's not in the waiting room. Can you hear me?
I can hear you.
Oh, there she is.
There you come. You're her.
Good afternoon, Ms. Wynn. Can't hear you.
Good afternoon, Judge. How are you? Try again.
Better. We were just discussing the probability that the motion for leave to amend is moot and the first amended petition is now properly before the court. Do you have any reason to disagree with that?
No, sir.
Okay. Then we are here just for determining the special exceptions to the first amended petition for divorce in this case. And since they are your exceptions, you may proceed whenever you're ready, Ms. Wynn.
We have all the people here that need to be here.
Well, Ms. McClyman and you are here. The others, it's optional.
Well, I know Mr. Jenkins and Ms. Nixon were planning on joining us.
We're both here.
Oh, I'm sorry. Okay. Just didn't see you on the screen. Apologize. Okay, so Judge, I received their response at about 1:05 and it's 7 pages, so I barely made it through it. but the purpose of special exceptions are to allow people to adequately prepare their case or their defense. And we just filed 4. The first one is on page 5 of paragraph 12, where they pled that certain sections of the family code apply to gift deeds. And the sections that they cited are for marital property agreements or agreements to convert separate property to community property. So I think that paragraph can apply to the 4 other agreements that they referenced, but a gift deed is neither of those. And so if there's another section of the family code that applies to a gift deed, we want to know what it is.
Ms. McClyman?
Do you want me to respond to that specific one, or can I respond in general to the special exceptions and then go with my individual responses? The reason I ask that is because I have concerns that this is not even the proper mechanism in which her objection should be heard. The Texas Family Code under section 6.402B states that special exceptions, specifically, it states that allegations of grounds for relief or matters of defense stated in short and plain terms in a petition for divorce are not subject to special exceptions because of form or sufficiency. And so I think that a motion for summary judgment or a motion to dismiss would have been the appropriate tool for Ms. Nguyen to file. And if she had filed those on Friday, it would be ripe to have it set for May 10th. But I wanted to make the court aware that we have a objection to these based on the family code. And then with respect to the specific special exception number 1, I think that there is some case law that talks about gift deeds being construed as exchange agreements. And that's why I put that in that section. And the family code, I cited the very specific sections in our response. And I apologize, I was in court this morning. And so by the time I got out of court, I filed my response. And in our response, I walked the court through the exact paragraph that Ms. Nguyen is making the special exception to. And in that, we list out 5 alleged agreements. I want the court to be able to consider whether or not the gift deed is acting as an exchange agreement, a postnuptial agreement under sections 4.001 through 206 of the Texas Family Code that addresses premarital and postnuptial exchange agreements. And so that's why I pled it that way. And I feel like I've placed Ms. Nguyen on notice because I did cite the code.
So you're not claiming to broaden anything in your allegations beyond what was in the first part of that paragraph?
No, I don't. I mean, the subsequent paragraphs go further into our claims regarding the gift deeds and agreements that were entered into during the marriage. But I think I've placed her on notice regarding the fact that I'm going to make an allegation that the gift deeds could be treated as an exchange agreement under the post-nuptial agreement provisions found in the family code. And so that will be one of the arguments that I'm going to make when we start the trial on May 10th. And with that said, I've been working on, it's very lengthy at this point, but I am preparing a trial brief, and it will be filed 7 days before the trial commences, but it will explain all of our legal arguments to that extent. So I don't think the pleadings need to be amended, and I don't think that the rules require that the pleadings be more detailed than they already are.
Well, As far as your general objection, I'll overrule that. And as far as the specific objection, do you have a reply to her response? Now, Ms. Wynn?
Judge, if I understood Ms. McClyman, first of all, let's address the 6.402 issue, where she says that we shouldn't be specially accepting to a divorce petition because you're not supposed to allege facts. That section, and I've briefed this several times, I didn't know that was what she was going to raise, but that section was added in 1997, and the purpose of it was so that people wouldn't say ugly things about their spouse in their pleadings under the grounds for divorce. These pleadings have to do with causes of action for breach of fiduciary duty and fraud and constructive trust. Those causes of action fall out of the family code. And in any civil lawsuit, if I was filing these special exceptions, we wouldn't be having this argument. So I know a lot of family lawyers think that that section applies to anything that's in a divorce pleading, but the purpose of it and what it applies to are the grounds for divorce. Secondly, saying that she's read something that says a gift deed could equal an exchange agreement doesn't equal those sections of the family code applying to gift deeds. If she's going to limit her claim to violations of the Texas Family Code to those specific sections on the gift deed, then we can move forward and we know how to defend it. But if there are any other family code sections that she is going to claim apply to the gift deeds, not the marital property agreements, then we need to know about it.
Well, as I understood what she said, she's limiting her family code sections to 4.001 through 206.
With respect to whether it's going to be, we're making the argument that if the court finds that it was an exchange agreement, that we would want those provisions to apply in determining whether it's an enforceable exchange agreement between the parties. But we're also asking, and I think we've agreed by consent to try the issue, typically the issue of whether it's a void or a valid gift deed would be tried under the property code. But because of this case, there was the district court case, we could go put those claims and causes of action under that case, but it wouldn't make sense for judicial economy to go try that separately. So that's why we've entered this agreement to have you determine that. And so we are asking the court, it's not under the family code, but for that limited issue of if the court finds that it's not a valid gift or it's an invalid gift deed or it's a void gift deed, I don't want them to say, well, that was an exchange agreement. I want the court then to have ruled that it's not a valid exchange agreement under the post-nuptial agreements. I'm trying to cover all my bases to make sure that they don't come back and have another bite at the apple.
All right.
I don't know what an exchange agreement is, and that's not what these sections of the family code deal with. So what I think I heard Ms. McClyman say is if you find that it's a valid deed, then she wants to challenge it under the family code as an exchange agreement.
4.102 talks about exchange of community property and exchange agreements. And that's why I'm making the reference to exchange agreement, because it's in the code. So I'm just making sure that if the court finds, yes, that it's not a valid gift deed or it's a void gift deed, I don't want them to come back and say, well, this was a partition agreement or this was a postnuptial agreement. I want to make sure that that's also been ruled out with respect to those two deeds.
4.102 has to do with the partition or exchange of community property. And I think one of the only facts that we can all agree on in this case is that the cross deeds conveyed separate property to the other spouse's separate property estate. So there's no applicability to 4.102 or anything that has to do with agreements to convert separate property to community property.
Is there some other statute that you're trying to bring before court other than what you have mentioned here?
Not other than what I've cited in my pleading, Your Honor.
Okay, well, I'll deny the special exception number 1. Let's proceed on to number 2.
In the second paragraph of paragraph 12, they attempted to invoke the quote statutory affirmative defenses as to invalidity and unenforceable. And so the request there is that they have to show what statute gives rise to these affirmative defenses so that we can properly prepare our case. Just saying something is an affirmative defense does not make it so.
All right, Ms. McClyman?
I mean, we are outlining, I mean, in that section, we're talking about the gift deeds and we're talking about then the affirmative defenses that stem from the execution of the postnuptial agreements and the gift deeds. And so we're asserting and we're talking about our statutory affirmative defenses. We are going to file in response to Ms. Nixon's counter petition. We're going to file a answer to address all of the affirmative defenses, even though we're not required to. We're going to assert all of those, but I don't think that we are required. Again, the case law that I've cited in our authority section in our response, I don't think we're required to specifically list each one out. And Ms. Wynn relies in her motion on this. She quotes the Mowbray case, and she states that special exceptions may also be used to determine whether a party has stated a claim or defense permitted by law. But that case literally does not say or defense. And so I don't believe that I'm required in my petition to specify the facts that are underlying each of our affirmative defenses. I think that that's going to be obtained through discovery or through our answer.
Judge, I'm not asking for the facts. I'm asking for identification of the statute that gives rise to the statutory affirmative defenses she's asserting. It's either in a statute or it's not.
They are in the statute, and the statute states that they can include other defenses. It's not it's a non-exhaustive list under TRCP 94. And so I don't have to just be confined to the ones that are listed. It says or other defenses.
I agree that TRCP 94 is not exhaustive, but it either has to be in that list or there has to be case law that's recognized it as a valid affirmative defense, or you have to tell the court, I'm trying for a new cause of action that I'm asking you to recognize. So if the only statute that you're referring to in that pleading is rules of civil procedure 94, is that what I understood?
No, Ms. Wynn, and Mr. Morris, I'm going to actually let him talk about this because that's more his realm. And so if Mr. Morris can answer this question.
So I believe that at this point, we're arguing both paragraphs 3 and 4 of the special exceptions of Ms. Nixon.
Yeah, I've only, excuse me for interrupting, but he just asked me to lay out the second special exception. So I haven't made any arguments about the other parts.
Well, okay. So just backing up specifically to the your paragraph 3, special exceptions, it specifically states in there that you're challenging affirmative defenses through the special exceptions. That is not a proper mechanism with which to challenge an affirmative defense. An affirmative defense can only be challenged through a motion for summary judgment, no evidence, or traditional, or a motion to dismiss. The Mr. Nixon is not required in any capacity to lay out all the details and the facts as you allege in your paragraph 3. The fact that you are put on notice of the affirmative defense is all that we required you to do. And if you have a problem with the legal validity of it, then you need to challenge that through a no evidence motion for summary judgment.
Your Honor, if you will recall, back in February, when we were discussing how we were going to proceed, you said, don't you think some of this could be handled by motions for summary judgment? And Mr. Nixon's lawyers said, no, we can't get there on that because we need facts. So we need an evidentiary hearing. So that's what I began preparing for. And I go back to my original argument. If there is a statute that gives rise to these affirmative defenses, then they need to tell us what statute it is. If it's TRCP 94 and that's the only one they're going to rely on, then I understand it. But otherwise,
that's not what you're asking in paragraph 3. You're asking that an affirmative defense must set out new facts or facts that operate to defeat a claim, even if the facts supporting a claim are true. Petitioner should replead to show proper authority under the defective parts. So you're asking us to go above and beyond what is required of an affirmative defense, and you're using the wrong mechanism to do it.
I beg to differ with you, because if you're relying on TRCP 94, invalidity and unenforceable are not in there. So if there's another statute that you are relying on for asserting those, then we're entitled to know what statute it is, because those are not contained in the list in TRCP 94.
All right, I'll sustain special exception, the second one, as to the second paragraph of paragraph 12, in that you'll be required to replead to specifically identify each statute under which you're claiming a statutory affirmative defense. But you don't need to plead all your facts to support that.
Yes, Your Honor.
Our third special exception has to do with the third paragraph of paragraph 12, wherein Mr. Nixon invoked 12 affirmative defenses. And we believe that fraud and duress are proper affirmative defenses. And I agree that the presumption of community property is an affirmative defense, which we'll be able to overcome. But there's nothing in TRCP 94 or any of the cases, the many cases that they cited that I read, that establish an affirmative defense of negligence or an affirmative defense of overreaching, undue influence, rescission, unfairness, dishonesty, and inequitableness. Those are not proper affirmative defenses. And then with regard to the affirmative defense of novation, which I believe is a valid affirmative defense, you have to show which contract, old contract, you're alleging has been replaced by a new contract.
Again, TRCP 94 is not an exhaustive list. Again, we're not required to plead all the facts. We're not required to cite case law in a pleading showing that an affirmative defense is valid. If she believes that our affirmative defenses are invalid, they should be challenged through another mechanism, not through special exceptions.
That's correct. You can't defeat an affirmative defense on its merits by a special exception. That has to be done by either summary judgment or ruling at the conclusion of the evidence.
But Your Honor, I am allowed by special exception for them to either tell us the statutory grounds for their affirmative defense or the case law grounds for their affirmative defense.
Now, that one is overruled. Okay, your next one.
Paragraph 15, wherein they alleged violations of the Texas Penal Code. And we specially accepted and said that if they're going to allege violations of the Texas Penal Code, we need to know what sections they're talking about.
And I can talk a little bit about this. What we asked for was not that there be a finding that she had violated it, but that if the court did see that there was a violation, that it be used, and this is more of a final trial issue in determining the disproportionate division of the assets. And so there will be evidence put on at final trial about Ms. Nixon's actions that could arguably be violations of the Texas Penal Code. And we would want the court to take that into consideration when dividing the community estate. But like I stated in our response, the Texas Penal Code doesn't create a private cause of action for penal code violations. We're not asking the court to find that here. We're just asking the court to take Ms. Nixon's conduct, intentional conduct, into consideration when making a determination on the disproportionate division of the community estate. And I don't think that, I mean, when we look at the fair notice standard that's required, I think that we've placed Ms. Nguyen on notice that we're asking the court to take that into consideration as one of the factors in a disproportionate division. I don't think that she needs or is entitled under a special exception to anything more than that. She has been placed reasonably on notice about what we're asking the court to do. And we attached, or we provided to the court the Richardson case, and that kind of outlines with respect to a divorce case what the burden is for us to establish in our pleadings, and we're not required to go into specificity of the exact allegations. There are several provisions in the Texas Penal Code that we may talk about, or the court may determine or surmise that Ms. Nixon arguably has violated based on her conduct. I don't think we're required to cite all of them in our pleading when we're asking the court just to consider it in its division of the assets at final trial.
Where in your pleadings do you raise the issue of any violation of the penal code?
It's just in section, it's section 16, Your Honor. We just stated that we were invoking the discovery rule and the doctrine of relation back, that Mr. Nixon asserts and alleges the below stated causes of action. And then after this section's where we go into our breach of fiduciary duty claims and all the other tort claims that we've included in the petition for divorce. But we talk about, to the extent that the claims stated herein for violation of the Texas Penal Code do not provide for an independent civil cause of action or claim for relief, Mr. Nixon's just requesting that the court consider her violations in making a disproportionate division of the community property estate of the parties. We haven't specifically made any allegation or asked for any tort relief related to a violation of the Texas Penal Code. We're just asking the court to consider it in the final division of assets. So it's literally what we state our relief that we're asking for is in that section. I don't know how any more specific I could be for Ms. Nguyen.
the Texas Penal Code is pretty big. There are parts of it that you think Ms. Nixon has violated. I think we're entitled to know which sections those are in order to adequately prepare a defense. I've never had a case, family law case, where the Texas Penal Code was invoked.
In the Izzo case, which dealt with John Izzo, he's an attorney out of Georgetown. That case talked about his violations of Texas Penal Code and how that, with relation to his breach of his fiduciary duty to his wife, non-attorney spouse. And so I don't think I need to state the specific provisions of the penal code that may come into place. If the court wants me to, I'm happy to do that. I just think that the appropriate avenue to do that would have been through a motion for summary judgment and not a special exception.
I think the judge is off the line.
Yes, I don't see Judge Langley on the line. If y'all just want to give us a second and we'll give him a call.
Judge Langley, he lost internet connection, so hold on a second. He is attempting to get back on. So just want to let you all know.
We're just glad it's the judge and not one of us, so we're
Exactly.
good.
All right. Sorry, I lost my internet connection. I had to swap over to my hotspot. Can you hear me?
Yes, Judge.
Okay. All right. Did you get my entire ruling before I got cut off?
No, Caroline, Ms. McClyman was talking about the penal code, and then we lost you.
Okay. Well, I'm going to overrule that one. And so the only exception I'm going to sustain is the one that requires Ms. McClyman to replead to specify the statutes under which she's claiming any affirmative defense under that paragraph 2, under paragraph 12. All others will be denied.
Judge, let me make sure I understand your ruling on the penal code. We could go to a full hearing trial on the merits under the way this is pled and not be allowed to know which sections of the penal code she alleges are being violated?
I don't believe she is raising a separate cause of action under the penal code. She is simply using references to any penal code violations as a consideration in a disproportionate division. And because of that, since it's not a new cause of action, and she's not a district attorney or a county attorney, she can't prosecute a crime in this case. Okay?
I'm relieved to understand that, and I do understand, but if we're going to have a disproportionate division argument, surely at that point, they would be forced to show us which parts of the penal code are alleged violations.
Well, they don't even have to have a penal code violation to obtain a disproportionate division.
Oh, I'm well aware of that. I've just never seen somebody allege that and then not be required to show why they would be entitled to that.
Oh, I see it all the time.
For violations of the penal code?
Family violence.
Then I'd know which section of the penal code that we're talking about. That's my point.
Okay.
Obviously, there's a limited amount.
I understand, Ms. Wynn, that you don't agree with what I have ruled.
Okay.
You have a right to appeal the decision.
Understood.
Okay?
Yep. Yes, sir.
All right. Anything else?
No, Judge. How
So we are scheduled for 10 a.m. on May the 10th.
Yes, Judge. And then when do you want me to have my amended pleadings to Miss Wynn by?
Today is the 21st. Can you have it to her by the 30th?
Absolutely.
That would give at least 10 days prior to trial.
Yes, Judge.
Okay.
And Your Honor, could we also get an agreement on exchange of briefs prior to the proceeding? The timing of that?
7 days. I would like to request 7 days prior to trial.
Is that all right with you, Ms. Wynn?
Yes, sir.
Okay. So what else can I do for you or to you today?
You can share those cookies with us.
Virtual cookies.
I think that's all, Judge.
I have
Thanks.
enough here to share with everyone.
As I tell my kids, sharing is caring, Judge. Well, thank you. We appreciate your time, and we will see you on May 10th.
I will be in Bastrop, Texas on the morning of the 10th.
Wonderful. Thank you, Judge. Are we excused?
Yes, ma'am.
Thank you,
Thank you.
All right.